All right, good afternoon. It's time for the Rains-Feldman Cyber Liability Update. I'm Eric Syverson. We have Steve Gebelin on my right and Scott Lesowitz on my left. We're here to talk about internet law issues, and this week we have a game changer in a lot of ways, we think, but maybe not. Who knows? We're going to talk about a case here in California that could affect the Section 230 of the Communications Decency Act. And just to set the table, that is a law that says that websites or internet service providers cannot be held liable for the tortious acts of their users. So, the way it often plays out is, let's say somebody on Yelp defames a restaurant. The restaurant cannot sue Yelp for defamation. The restaurant would have to sue the poster. So, Steve, you're going to talk to us about a case that may alter that a little bit. So, what's happened?
So, this is a new case just issued by the California Appellate Court and certified for publication. So that means other courts in California are going to be able to cite to this case as a precedent on what to do. In this case, the plaintiff obtained an order.
Well, let me stop you there.
Yeah.
What is the case called?
The case is called Hassell versus Bird.
Okay. And what are the background facts here?
Background facts here. Hassell is an attorney in San Francisco, represented this client Bird for a few weeks. They went their separate ways. A little bit after that, Bird posted something on Yelp defaming Hassell, saying, "You didn't do any of the work, you were awful, you didn't talk to me." And Hassell went to him and said, "Hey, this is false, take it down." Didn't happen. It didn't get taken down. Hassell filed a case, got a court judgment against Bird saying that Bird posted 3 different statements under pseudonyms that were defamatory against Hassell.
Now, let me stop you there. Did Hassell obtain a default judgment, or did she actually go through to trial and win?
In this case, it was a default judgment, but it was a default judgment after a hearing in front of a trial court judge.
Okay.
So,
And so there were pseudonyms used by the defendant, so we're assuming that Hassell served subpoenas and proved it up, or do we not know that from the opinion?
from the opinion, we don't know that. It actually appears that just based on the testimony of the plaintiff alone, they tied the pseudonyms to the defendant. One had a name that was similar to the defendant's name. The other one was posted near the same time as the one with the similar name and contained similar facts and statements.
Interesting. So it could have been a judgment based on what we would probably consider circumstantial evidence. So
Yeah, absolutely.
So Hassell gets the judgment, and she's got a judgment against the defendant, and then
Right.
Hassell probably wants the reviews to come down. That's what
Right.
clients normally want, plaintiffs normally want in these cases. So what happens next?
So not only does Hassell get a judgment against Bird for a couple $100,000 in damages, but also gets an injunction. And part of that injunction requires Bird to take down these reviews from Yelp. And then another section of that injunction also orders Yelp to remove the defamatory reviews.
Now, at that point in the case, was Yelp a party already?
Yelp was not a party to the case at this point. But the court issued an order against Yelp as someone who was connected to the acts in question of the defendant that were at issue.
So it sounds like the court, viewed Yelp almost as a tool or an agent under the control of the defendant. So Scott, normally it would be a due process problem with regard to Yelp, you would think, right? How can a court order Yelp to do something when Yelp wasn't at the party?
Yes, that obviously is an issue. It's in the past, courts have been reluctant to do this, and that's partly why this case is such a game changer.
And so, Steve, to get back to the procedural posture here, I imagine Yelp did not take too kindly to this this order by the court, or permanent injunction, if you will,
Right.
as part of a judgment. So what did Yelp do?
So at this point, after receiving its order against the defendant and against Yelp, the plaintiff took it to Yelp and said, hey, comply with the court's order, you have to take it down. Yelp objected, refused to take it down, and became a party to the case at that point, asking first the trial court and then later on appeal, asking to get this injunction overturned, and especially the part against Yelp, the injunction as it pertained to Yelp and requiring it to remove this from Yelp's page.
So, you know, it's interesting that Yelp wouldn't want to remove reviews that have been adjudicated to be garbage anyway, you would think. You would think that Yelp is interested in providing something that's valuable, which is valuable, accurate consumer information, not demonstrably false reviews. So
Yeah.
that's a little surprising to me that that Yelp internally would not decide to remove these. But
Well, I think
go ahead,
there's,
Scott.
I think there's an argument here, and that is that Yelp is afraid of their users being sued and want to do what they can to stop that. There's only so much they can do, and the one thing they can do is send a message to plaintiffs that if you sue, you're only going to get so much relief because you're not going to get this taken down unless the user chooses to, because what they're afraid of is just like this. Someone gets sued, doesn't want to hire an attorney, pay the money to hire the attorney, and then defaults, loses automatically, and then the post has to automatically come down. It's some of the incentive not to sue is now removed.
That's true, and you know, that's interesting, Steve. Do we know from the facts, I guess, because we know that posters of Yelp reviews, I think in my experience, they can remove them. So the defendant here
Yeah.
just went MIA, I'm
Yeah,
guessing?
in this case, the defendant failed to remove it. There's an indication in the opinion that the defendant might have been judgment proof, and that
Mhm.
might be part of the issue. Why they chose not to comply anyway is you can't do anything to me, so I'm gonna leave it
But it
up.
might be able to lock the defendant up, the court. If
Yeah,
the court's
I mean,
inclined to.
it-
If somebody disobeys the court's order, I think the judge could have tossed this defendant in jail, but I guess that didn't happen here, so.
Well, what do you do if it's a defendant based abroad? I mean, granted, in this case, with an attorney, that's not
Well,
likely
that's
to be
true,
the case.
yeah. Well, I'm assuming the defendant was local and within the reach of the court here in the Bay Area, but that's a good point. A lot of times we have cases where the defendant is abroad.
Yeah.
And so in that situation, this scenario becomes very important. So, so Yelp appeals saying we weren't at the party, this is a violation of our due process, or did they invoke section 230, or both? How did it go down?
Yelp actually, its appeal rested on a couple different grounds, and the court didn't agree with Yelp on any of them. The first ground was obviously the standing issue, saying, hey, we weren't a party to this case, you can't enjoin us.
Mm-hmm.
And that's the first argument.
And the court said, well, you're an agent or a tool of the defendant, so we're not
Right.
having that.
Yes, so really it aligned this injunction with other cases in California history where you can enjoin someone that the defendant is acting through.
Mm-hmm.
So in this case, the court says, Yelp, you're the person, you're the instrument through which the defendant is keeping this defamatory statement out there, we can enjoin that. And that's completely within the scope of what an injunction.
Boy, that is
Yeah.
a real game changer. This is gonna go to the California Supreme Court, I'm sure. I mean, if you're Google or Facebook, you will do not like that line of reasoning at all.
No.
Okay, what else did they argue?
The next line of argument that Yelp had was free speech claim, saying by restricting us from being a publisher of this, you're impinging on our free speech rights. And they cited in that instance to the United States Supreme Court cases regarding publishers that circulated what were sometimes considered obscene materials. And there was a line of cases on that. But again, the California Court of Appeal in this case said, no, this isn't infringing any free speech right that you have here. These specific statements have already been determined to be defamatory by judicial decree. There's
no First Amendment protection.
there's no First Amendment
for
protections on those,
defamatory speech.
on these. The First Amendment protections for speech apply before a statement has been determined defamatory, not after.
Yeah, that was a bad argument if that was raised by Yelp. But anyways, didn't work.
Yeah. And then the final argument, which is sort of, has been one that's carried out across the internet, is something that these kind of review sites rely on, is the CDA 230 immunity that you talked about at the beginning of this chat. And on that, Yelp said, you can't enforce an injunction against us because that would hold us liable for the content of that speech. And the court disagreed, said, no, the order isn't holding you liable for this speech. It's not holding you liable as the publisher or speaker, it's just requiring you to take it down. It's not the same. And the court even threw in a little bit of dicta saying, and additionally, we think you could be held in contempt if you failed to comply with the order.
All right, we hope you enjoyed that. That's it for the Rains-Feldman Cyber Liability Report. Catch us next time.